Hello LiveLaw viewers and welcome to Courts Today. Here are today's top legal headlines. Hinting at a CBI probe, the Supreme Court has said that nexus between banks and builders must be investigated. The Delhi High Court has issued notice on a plea seeking separate website for Rouse Avenue Court. The Supreme Court has set aside Bar Council of India's non-recent order dismissing a complaint against a law firm. The Apex Court has slammed the Punjab government for disowning undertaking given by the Additional Advocate General before the court and has now summoned the Chief Secretary. While granting bail to a mother accused of sexually abusing her breastfeeding daughter, the Kerala High Court has said that complaints by men against women are not gospel truth. And the Delhi High Court has held that awarding less than minimum prescribed sentence under Wildlife Protection Act would frustrate its object and sets a dangerous precedent. I am your host Urvashi Chauhan, bringing you the latest legal updates that matter the most. From key court rulings to significant legal developments, we have it all covered. Watch till the end for a complete roundup, and if you find this update useful, make sure to like, share and subscribe. The Supreme Court has shed light on a possible nexus between real estate companies and banks that sanction loans for their projects in the National Capital Region. Observing that poor home buyers have been held to ransom, the Supreme Court has hinted at ordering a CBI investigation into the alleged builder bank's link, signaling strict scrutiny of those responsible for project delays and financial mismanagement. A bench of Justices Suryakant and N. Koteshwar Singh was considering grievances of home buyers in the NCR who claimed that they were being forced by banks to pay EMIs without having obtained possession of flats due to delay by the builders or the developers. According to the home buyers, they invested in flats under a scheme where builders were supposed to pay the EMIs on bank loans. However, when the builders stopped making these payments, banks started demanding the money from home buyers instead. The home buyers argue that the banks wrongly gave the loan money directly to builders, ignoring RBI rules. They claim that they were just used as a way to get loans approved while the actual funds went straight to the builders. Now, even though home buyers never received the money, they are being dragged into legal battles. They say both the banks and builders violated agreements and RBI guidelines and that there is no proper legal protection for them, especially when builders go bankrupt, but banks still keep asking them to pay the EMIs. In the backdrop of the builders and banks not giving details of delayed projects in NCR as well as the current status of their construction and people having invested their hard-earned money, the bench opined that an in-depth investigation was needed to unearth the nexus between the builders and the banks. The court also indicated that conduct of resolution professionals should be examined as well. The questions to be gone into by CBI are likely to be formulated by the court on the next date. In today's digital era, access to legal information is crucial for lawyers and litigants alike. Court websites serve as vital platforms for case updates, notifications, and e-filing, making the judicial process more efficient and transparent. The Delhi High Court has issued a notice on a petition seeking creation of a separate website for Rouse Avenue Court. The petition filed by lawyer Abhinav Garg argues that Rouse Avenue Court does not have its own website despite being a distinct entity within the Central District. While other district courts have dedicated online platforms, the absence of a separate website for Rouse Avenue Court creates difficulties for lawyers and litigants who rely on digital access for case statuses, circulars, and e-filing. The plea highlights that Central District's existing website does not provide direct reference to Rouse Avenue Court, leading to confusion and delays in legal proceedings. The petitioner has contended that a unified website for all courts in the district makes it difficult to find court-specific information for Rouse Avenue Court. He also urged the court to direct the creation of an independent website to streamline operations, improve accessibility, and ensure efficient functioning of judicial system. Well, Justice Sachin Datta, issuing notice on the plea, has sought a response from the District Judge of the Hazari Courts, the Ministry of Law and Justice, and National Informatics Center. The respondents have been directed to file their replies within 3 weeks, and the matter matter is scheduled for hearing on 14th April now. In the next update, the Supreme Court has set aside an order passed by the Bar Council of India dismissing a revision petition filed by a litigant alleging professional misconduct by advocates Alok Dheer and Manisha Dheer, who are partners of the law firm Dheer & Dheer Associates. The complainant in this case, Shailesh Bhansali, filed a complaint against the law firm which he had hired to handle a case before the Debt Recovery Tribunal for his company Madras Petrochem. He alleged that the firm had a conflict of interest because the same partners also ran an asset reconstruction company called Dheer & Dheer Arc. This, he claimed, gave the ARC access to confidential financial information about Madras Petrochem. According to Bhansali, this situation allowed Dheer & Dheer Arc to acquire the loans of Madras Petrochem and become its largest lender. He further alleged that the lawyers misled him into signing a no objection letter for their representation by not fully disclosing their connection with the ARC. The Bar Council of Delhi had dismissed his complaint, stating that Bhansali had already issued a no objection letter which indicated his consent for the law firm's involvement in the case. So he filed a revision petition before the Bar Council of India against BCD's decision, but the same revision was rejected by BCI, prompting him to approach the top court now. A bench comprising Justices Dipankar Datta and Justice Manmohan has noted that without recording any reason at all, the BCI rejected the revision petition. The court stated that while it could uphold the Bar Council of Delhi's order, simply affirming it without any reasoning would not be acceptable. Even if detailed explanation were not necessary, some reasoning had to be provided. The top court has now directed the BCI to reconsider the revision petition and pass a fresh order after hearing the parties in accordance with law within 6 months. In another update from the Supreme Court, it has strongly criticized the Punjab government for failing to fulfill a promise made in 2002 to implement a scheme. The Punjab Privately Managed, Affiliated and Punjab Government Aided Colleges Pensionary Benefits Scheme of 1986 was introduced to provide pension and retirement benefits to employees of privately managed but government-aided colleges in Punjab. It aimed to ensure that teaching and non-teaching staff of these colleges received pension benefits similar to government employees. Back in 2001, the Punjab and Haryana High Court was assured by the state that the pension scheme would be implemented within 3 months. Again, in the year 2002, Punjab's Additional Advocate General gave an undertaking before the High Court promising that the scheme would be published and implemented by June 2002. However, instead of following through, Punjab introduced a new pension rule in 2002, which ultimately led to years of delays and repeated adjournments in the court. In 2012, the state even introduced a bill to repeal the original pension scheme, making it ineffective retrospectively. Now, the state is trying to distance itself from its earlier commitment, arguing that the undertaking was given by an officer and not the government itself. The Supreme Court has strongly objected to this argument, warning that if such excuses continue, courts may have to demand multiple affidavits for every assurance made by the state lawyers. The bench of Justices Abhay Oak and Ujjal Bhuya has issued a notice to the Punjab Chief Secretary K.A.P. Sinha, asking him to explain why contempt proceedings should not be initiated against him. The court has also called on another state official, the Deputy Director of Public Instruction Colleges, to explain why he filed a false affidavit claiming that employees had not opted for the scheme when in reality the scheme was never even implemented. The court expressed a strong disapproval, stating that it will no longer accept verbal assurances from Punjab's lawyers and will now require written affidavits from responsible officers. Punjab's Advocate General Gurminder Singh assured the court that the government will take action and present a positive update. The matter is now set for next hearing on 24th March. Stay tuned. In another update, the Kerala High Court has granted bail to a woman who was accused by her husband of sexually assaulting her 1.5-year-old daughter. The court found the case was registered purely on hearsay evidence and criticized the way matrimonial disputes are turning into criminal cases. The child's mother here was booked under the POCSO Act after her husband filed the complaint. He alleged that he heard from another woman that his wife was sexually abusing their child. Based on this, the police registered an FIR under POCSO for aggravated sexual assault on minors. However, the High Court was shocked that such serious charges were filed solely based on hearsay evidence, that is, based on what the husband heard from another woman. Justice P.V. Kunnikrishnan relied on a recent ruling in Naushad K versus State of Kerala, wherein it was stated that complaints made by a woman should not always be treated as the absolute truth, and the same principle applies to complaints made by men against women. In this case, the High Court also noted two major points: that the couple was involved in a matrimonial dispute and that there was an ongoing custody battle over their child. The court further observed that the sub-inspector of police himself reported that further inquiry was needed, which indicated that the police was not fully convinced about the allegations. Therefore, the court granted bail to the mother while expressing serious concerns about how marital conflicts are turning into false criminal cases in our country. It also has ordered that if the allegations against her are found to be false, action must be taken against the husband for filing a false complaint. And lastly, the Delhi High Court has ruled that courts cannot award sentences lower than the minimum punishment prescribed under Wildlife Protection Act of 1972. Justice Chandradhari Singh emphasized that the law was enacted to protect biodiversity and curb illegal wildlife trade, and diluting its provisions would set a dangerous precedent. The case here involved some individuals convicted for possession of 8 Shahtush shawls, which are made from wool of the endangered Tibetan antelope and are banned under Schedule 1 of the Act. These shawls were seized from the accused in the year 2005. Initially, they were sentenced to pay a fine of 10,000 rupees each, but after CBI's appeal, it was increased to 20,000 rupees with imprisonment limited to the time already served. The CBI argued that this was illegal as Section 51(1)(a) of the Act mandates a minimum punishment of 3 years, which can extend to 7 years, and a fine of at least 10,000 rupees. The Delhi High Court criticized the special judge's order, stating that it weakened the enforcement of wildlife protection laws. It emphasized that possession and trade in banned wildlife items are serious offences, even if the accused were not directly involved in poaching. Justice Singh stressed that courts do not have the discretion to reduce the minimum sentence when it is explicitly mandated by law. So the High Court has set aside the lenient sentence and has remanded the case back to the special judge, directing a fresh sentencing order.